Probation hanging by a thread, a judge ignored by the police, and defense lawyers trying to crush the case before trial. This courtroom has everything. Let's break it down.
Good morning, dear James Loftton. And it looks like there's a motion to revoke probation in Mr. Lofton's case and cause number 1624485. And what's the announcement?
Y'all, the announcement is the state makes some plea offers. We're probably going to take a police for a day of service to do that. Or I need to wrap up this case. Off the ice.
Okay. When is the misdemeanor set?
Misdemeanor just in.
Which they'll always move it up if you need to. There's issues like this. I don't want to think off the two.
No, I'd like.
Oh no, it'll be 30.
That's fine.
We're talking 2 or 3 weeks.
Yeah.
What is?
I've got a trial part 18th of August.
All right, we're going to reset it to August.
Right out of the gate, we're dealing with a motion to revoke probation. Translation: the state wants to pull back a second chance. Mess up on probation, and you could be heading straight to jail.
4 to 2 weeks for a plea on that motion. All right? We'll see you back then. We'll see you back in 2 weeks. Good morning. You're Alexander Thornton. And Mr. Thornton is charged with fraudulent use of possession of credit or debit cards in cause number 240323. And what is the amount?
Your Honor, state just makes a plea offer. We're still working on moving back to house. So we should be out there before it needs to. Thanks for staying with us. What we want to do.
Okay. All right. Because I know you haven't been on this very long, but you'll be good in 2 weeks.
Yes.
All right.
One way or another, we'll decide.
Okay.
If we have a trial on.
All right, we'll reset it in a couple of weeks. Mr. Thornton, stay in touch with Mr. Barrington so you can visit about the case, and then we'll get an announcement at the next. We'll get an announcement at the next court date. You're free to go. Good morning, sir. You're Dustin Drake. God bless you. And this is 242420. Mr. Lane, what is the announcement?
The court has allowed me one announcement. Medical food and treatment committee rights. Recently got out of treatment. I tried to get in touch with him for us to meet to go over the story. However, I sent the diligent litigation back. It's not really our intention to go to trial last week about his recovery and all. So I'm hoping that maybe if you allow me one more announcement.
All right, so this will be the last announcement. Get with Mr. Nichols, Mr. Drake. Make sure you stay in touch with Mr. Lane. So once he visits with Mr. Nichols, you'll know what your options are, and we'll get an announcement. It'll either plea or it will be going to the trial document. Okay? You're free to go. Thank you, sir. Thank you, Mr. Lane. Good morning. You're Gustavo Vasquez. All right, so we reset the case last.
Here's where it gets interesting. Mr. Drake has been in treatment. Judges love real progress, but they also know when someone's just buying time.
Week sentencing on Mr. Vasquez's case. I have now myself made a phone call to Officer Clark, Port Arthur Police Department last week, I think it was on Wednesday, and have not heard back. So that obviously leads me to believe that there is an issue if you not calling defendants back, but kind of feel like if a district judge calls you, you should call them back. So that I don't disagree that Mr. Vasquez, could possibly have done more, but I also don't disagree. It sounds like even probation has seen evidence that Mr. Vasquez has tried to do what he's supposed to do. And so based on that, I find it hard to revoke a probation when it looks like he's trying. Today, what I'm going to do after docket, since I have not received that call back, is talk to Chief over there about what is going on. Because it sounds like this is not the only case where there's some issues. I also know that I think Jody tried to call correct and also gave an email address and did not get a response either from probation from this Officer Clark. So That being said, what I'm inclined to do, because that is really the primary allegation, is continue the probation and have Mr. Vasquez continue to try, obviously, to register, but potentially maybe go on higher caseload so that he has to report more. If he can't get that done for some amount of time, at least he'll be reporting to you more often and things like that. Is there anything else that you could think of that would be appropriate at this point? We're about to talk also about treatment and some stuff like that. Okay. So, Mr. Vasquez, obviously there's an issue with the reporting, but I still have some concerns because Dr. Steers mentioned that your progress is below average and needs improvement, and that is not going to be acceptable after today. Do you understand? So you're going to do everything you're supposed to. You're going to continue to try to report, but I mean, regardless or register, regardless of that, you're going to do everything else on probation as well as possible. And below average needs improvement is not going to be acceptable. It's just not. So you're going to, what I'm going to do is, again, find that you entered your plea of true to count 2 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that. I'm going to continue that probation. You're going to be moved to a different caseload where you have to report more often, at least for some amount of time.
Whoa, did you catch that? The judge herself called the police and got ignored. That's not just disrespectful. It could totally change how she views the defendant's effort.
Until all of this gets worked out, okay? The concerns that I have are with you, and then I have just as big concerns with what's going on up there, because these are cases where obviously we need to know where everybody is, and if we don't have someone taking care of that in that office, then I think the community is at risk. So I'm gonna work on that separately. Let's see, is there any minute? All right, that's really it. Just all right, so you need to make sure you attend every appointment with Dr. Steers, follow through with everything you're supposed to, engage in that, whether you think you need it or not, you're ordered to do it. And so just going and showing up and doing the minimum amount of work is not going to work, because if you don't complete that in an appropriate way, it's a violation of your probation. Okay? All right. Y'all.
I'll let you see that. You see the direction.
Yes.
You know, call what happened in the probation office. I know. That way she knows.
I would say call every week until we get it worked out, and you are every single week. Leave a message. If he doesn't answer, don't just hang up. Leave a message with your name, what you're trying to do, and then that way there's some records, and you write down every time you do that. Again, just like Mr. Parker said, let your probation officer know, and we'll probably get on that. So, okay? All right. Y'all are free to go. Thank you. Morning, are you Mark Hebert? And will Mr. Hebert waive the formal reading of the indictment?
Yeah.
Mr. Hebert, in cause number 250455, you're charged with a third-degree felony offense of driving while intoxicated, third or more, from April 16th of 2024. The indictment alleges you were previously convicted of driving while intoxicated March 31st of 2010, and then after that, January 8th of 2013. How do you plead to that charge? And are those prior convictions true? Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you.
Yes.
And I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 5-year term in prison, but that would be probated for 5 years. You'd be on probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Also, it looks like there would be a dismissal, a misdemeanor kind of case. Okay. Sure. Yes, sir. Yes, ma'am. Is that your understanding of the agreement? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one. It's admitted. Is there any evidence that Mr. Heber's not incompetent? All right, sir. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're...
Classic tough love moment. The judge is laying it out. Step up or face the hammer. Probation isn't just freedom. It's a performance review you can fail.
Mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you at sentencing. Good morning. Are you John Van Wright? And it looks like there is an MTRP as well as a new case in cause number 24-2485 and 15-23582. What is the announcement?
Not formatted correctly. I'm trying to watch.
I'm going to reset it. Make sure you work on that early so that we're not figuring that out on the court. Mr. Van Wright, if you'll stay in touch with Mr. Mitchell, once he gets all that worked out, technology part, go in, watch that with him. That way you'll be better equipped to make an announcement. Okay, thank you. All right, thank you. Morning. Are you Alexis Bourgeois Cooper? And will your client waive the formal reading of the indictment? All right, Ms. Bourgeois Cooper, in cause number 24-1296, you're charged with the state jail felony offense of theft of property from April 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually...
Notice how carefully she goes over every right waived? That's legal armor. Later, the defendant can't say, I didn't know what I was signing. This protects the court big time.
They did what they've charged you. It has here on the computers and documents have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lane? And do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap 12 months in the state jail prison, which means you're leaving your punishment up to me. I can give you 12 months in state jail prison. I can give you less. I can give you probation. It all depends on the information I get when we come back to sentencing. You have an absolute right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they found you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and you're leaving it up to me. Do you understand? And as long as I don't give you more than 12 months in state jail prison, you're waiving any right to appeal. You understand that as well. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Okay.
It's admitted. Is there any evidence that Ms. Bourgeois Cooper is not competent? All right, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get probation to do a pre-sentence report, and that'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lane. He'll present it to me on your behalf when we come back. And as you're leaving the courtroom today, you need to stop and talk to probation and submit that desk right there. All right, see you back at sentencing.
And here comes legal chess. The defense is attacking the wording of the indictment itself. Why? If it's vague, the case gets weaker. Sometimes the battle is won before a jury ever steps in.